We wanted to take a minute to thank our strategic partners, as well as our sponsors who have helped promote the Caregivers Summit. Our strategic partners are the Alzheimer's Association of Eastern North Carolina and the Dementia Alliance of North Carolina, who provide very important resources for those navigating the complexities of dementia and Alzheimer's. We are also grateful to our sponsors for their financial contributions that make the Caregivers Summit possible. An extra special thank you to our gold sponsors, the Potter Financial Group, North Carolina Senior Medicare Patrol, and United Healthcare. Because of them, there was no charge for you to participate today. Today, we'll be talking about the essential legal planning for healthcare, and we're honored to have two experts to help us understand more about this topic. They are Mark Costley and Jonathan Williams from Clarity Legal Group. Mark Costley received his bachelor's in law degrees from Duke University. He has since been in the continuous private practice of law, having worked exclusively in the areas of estate planning and elder law in the Triangle area for more than 20 years. Mark's career has included service as a trustee of Duke University, chairman of the board of the North Carolina Humanities Council in Charlotte, chairman of the board of the Servant Center in Greensboro, and president of the Durham Orange Estate Planning Council. He has held the AV peer rating from Martindale-Hubbell, the highest rating for legal competence and ethics, for more than 25 consecutive years. Jonathan Williams is a graduate of Wake Forest University, earning bachelor's, master's, and law degrees there. He has since worked in private practice in the areas of elder law and estate planning. He was named a rising star in elder law by Super Lawyers in 2020 and in 2021. Mark and Jonathan, thank you for joining us today, and take it away.
Well, Mary, thank you very much. I appreciate that warm welcome, and we are so pleased to be part of the Caregiver Summit and want to thank Transitions Life Care for all their leadership in this area. We've been part of the summit for a number of years. We've had I think a deep commitment to it, and it means a lot to us to be part of it. The presentation today is in some ways very simple, but in other ways, it's the subtle nuances that can make it complicated. I've been doing planning with folks for their healthcare for, as you mentioned, more than 20 years, probably more than 25 years, and it's a big part of what we do at Clarity Legal Group. Jonathan and I have worked together for gosh, 6 or 7 years, and in that time, we've developed a real focus on this kind of work, and so I'm pleased to be able to talk about it today. Let's get on to the next slide and let me get into the meat of the healthcare presentation. Our objectives in the presentation as a whole are to give you just a detailed discussion of the healthcare directives so you understand how they work. To talk about how you can use a healthcare power of attorney to appoint a healthcare agent and let that person guide your decision making. It's really the foundation of all of this planning. Also, that you understand how a living will works, understand that it is your direction, your choice, not a situation where you empowered someone else, and then understanding how the healthcare power of attorney, where you have empowered someone else to make decisions for you, works with that living will. Also, another key document is a HIPAA authorization. We think of that as just a standard document because it is so frequently put in front of us when we're getting healthcare from various providers, but there are some strategic applications to how that is used and what you do. And then we're going to discuss in detail today really how the healthcare agent should view their role and what their duties are, and how that might influence the way you look at the task of serving in that capacity. So let's start by talking about the healthcare power of attorney. So we think of this as basically, to begin with, a legal document that's signed by the principal, the person who is naming people to serve for them. And the people that they are naming are referred to both in the document and in the statutes as the agent, the healthcare agent. We think it is a great idea that you name more than one person. Some people will talk to me about naming a co-agent. Can I have more than one? You can. We think there are some problems to that, which I might discuss in a few minutes, but certainly you should have a successor. You should name at least one primary decision maker and at least one backup. In some cases, more than one backup is a good idea. When you're choosing an alternate, understand that they may never serve, but you can give them a role as a consultant to the principal. So think about that as a possibility. The healthcare agent, the person you've named in the legal document, does not act until your attending physician determines that you are unable to make your own healthcare decisions. And when that physician, in effect, triggers the powers, then that healthcare agent steps into your shoes and they can begin to make decisions on your behalf. We tend to think of this as big decisions made kind of at the end of life or in a crisis. But I invite you to frame your thinking about who you choose as a healthcare agent as choosing not only someone who can make those kinds of big decisions, but also someone who might just be making the very mundane, routine, day-to-day decisions of healthcare during a period, if you might have an extended period of incapacity or dementia or something like that toward the end of life. So in that case, they might be doing something like deciding who your doctor is, or whether or not we ought to get a particular treatment that may be fairly routine. The things that your healthcare agent can do are pretty comprehensive. We want it to be. There is a laundry list kind of areas in which they have authority in the statutory form in North Carolina, which is a good guide. This includes choosing your doctors, admitting you to hospitals or other healthcare facilities, authorizing diagnostic procedures or even surgery, consulting about and making decisions about treatment plans, and then even making decisions about your mental health treatment. Basically, think of it this way, literally, they step into your shoes. And once your doctor has concluded that you can't make your own decisions, they are doing anything you can do. They don't have more power or authority than you have, but they have the same power. Now, the document itself, the healthcare power of attorney, it really creates some opportunities for you to guide that agent. But really the guidance that you provide really show up in terms of limitations on their authority, which is to say, you have the authority to act for yourself without limitation. Your agent might have some limitations, which might show up as they have to get a second opinion to authorize a particular procedure, or maybe even there are some things you don't want them to be able to deal with or authorize. So that's something you ought to think about in the process of putting together the document. The healthcare agent may also have some powers that extend beyond death, and that's actually fairly unique in North Carolina. As a general rule of thumb, a power of attorney, a healthcare power of attorney who gets their authority from you, their powers and authority ends with your death. But here in North Carolina, you can leave an instruction with respect to the disposition of your remains in your healthcare power of attorney that extends beyond your death. So before this became part of our statutory scheme, we thought of the will as a place to leave instructions about, do you want to be buried? Do you want to be cremated? Where do you want your remains to rest? Now that instruction can be in your healthcare power of attorney, can be to the agent in your healthcare power of attorney, and is legally enforceable. The document also authorizes the agent to carry out organ donation or perhaps donation of your remains for anatomical study. For those of you who, for religious or other reasons, don't want to authorize autopsies, the document specifically gives the healthcare agent authority in those areas. Now, I'm talking largely in my discussion about the statutory form North Carolina healthcare power of attorney. We think there's some real advantages to using that. Mainly because it's a scheme that healthcare providers are really familiar with, so that helps. But also, it's a pretty good document. People who have looked at other healthcare directives or powers and have seen some things they like about them because they're more specific. At Clarity Legal Group, we like to think about maybe incorporating those more detailed instructions in the healthcare power of attorney. And the healthcare power of attorney document in North Carolina specifically invites that. So we have an opportunity to do that. Now, typically in our powers of attorney, the healthcare agent is nominated as the guardian to serve for the principal in the event that a guardianship is necessary. Of course, having a healthcare power of attorney is one of the tools or devices that help us avoid a guardianship. But if we need a guardian, you're in effect saying when you name your healthcare agent, well, that would be the person who I would want to be the guardian of my person, the person in charge of how things are handled for me if a guardianship is necessary. So let's think about the structure of the healthcare power of attorney. All of these powers that I'm talking about come from the principal. The agent steps into the shoes of the principal. The document has limitations that might structure things that the agent can't do. And then you're also going to want to look in the living will for other limitations about end of life care. The living will is a directive from you that relates only to end of life care. And of course, the healthcare agent under the healthcare power of attorney has a seat at the table for these end-of-life decisions because they literally are representing you in those decisions. And of course, remember, their power is not triggered until your doctor concludes that you're unable to make your own decisions. So I just want to conclude talking about the healthcare power of attorney by talking about what should guide a healthcare agent. Ideally, it's an actual knowledge of what your wishes are. So more so than any other fiduciary you might appoint in your estate planning, more than your executor or a trustee or even a power of attorney. Your healthcare power of attorney is someone that I think you're well served to talk to. Talk with them about what your concerns are, talk to them about your wishes are, and guide them so they can more or less do exactly what you would want. So a healthcare agent who does a great job is going to be able to exercise their judgment based upon their knowledge of those witnesses. So wishes. Let me give you a quick example. For your financial power of attorney, if your financial power of attorney sort of disagrees with the way you manages your affairs, thinks you're reckless or make poor choices, their duty probably is to correct that and do a better job, to conform to some standard that is safe and prudent. But when it comes to your healthcare agent, and we're going to talk more about this later, I think your healthcare agent should be looking to do what you would want, regardless of whether or not they agree with it or not.
Hey, Mark, we have a couple questions for you, if that's okay.
Right? Sure.
First question, what characteristics should we look for when choosing a healthcare agent?
So I think that you're looking for responsibility, you're looking for availability. So this is one of the few fiduciaries you choose in the estate planning process that I would feel pretty strongly in favor of having someone who is local to where you are usually. So if you had two children, you're deciding between the two children, and maybe one of them was a little better than the other, but not a lot. But that one who was a little better lived on the other side of the country. I'd probably choose the one who was local, even though they weren't quite as good. On the other hand, if the one on the West Coast was 10 times better, I would still choose them. That's not the only criteria, but proximity can be a factor. They don't have to have any real expertise. I'll give you a quick example. You might have someone in your family who's a doctor, and you might think, well, gee, that would be the best possible person I could choose. But if they're a doctor with a busy practice, with a large patient load, guess what? They may not have time to do the job well. So you might want someone who has good judgment, knows how to have a good conversation and advocate for you, and has time to do the job ahead of that person who has maybe more expertise but isn't available.
It's great insight. One other question for you. Can you have co-agents?
Yes, you can have co-agents. I mentioned that a second ago, and I want to talk about it a little more. The downside of having co-agents is if you get into a situation where we're in kind of an emergency situation and timing is important, and we can't find both of the agents, and we want one agent to proceed. So if we do that, I kind of want to specifically draft around that and maybe say, literally just add language to the power of attorney that says if we can't find both agents, we, in a reasonable or prudent period of time, that one can act without the other. But you can do it, and I think what I would say about that is that's a perspective that is focused on those big decisions like major surgery or end of life decisions. But if we're thinking about something like who should be my healthcare agent for my everyday needs, like going to the doctor with me and listening to what the doctor says because I've got a mental deficit that keeps me from being able to do it. Well, that's pretty awkward if we need both of them to be there to authorize things. We want one person to be able to act independently. So we want to think about that when we're choosing co-agents.
Great. It looks like we have a couple other questions. If you choose to not use a family member for your healthcare agent, could a family member overrule that decision?
Well, the answer is, from a legal standpoint, no. In fact, having a healthcare agent is one of the important ways to exclude people who you don't want to have making the decision, right? As we'll talk about in a second, there is a statutory scheme of who makes the decisions when you don't have a power of attorney named. And so if, for example, I've got a family member that I don't want to have making the decision because they don't make good decisions, or because they may not have my best interest at heart, I want to make sure I have someone named as a means of keeping them out. I will say, and this is important for everybody to appreciate, that there's a difference between sort of the literal legal interpretation of these documents and the way they might be practically used in application in a hospital or a hospice or a healthcare environment. In a healthcare environment, your healthcare providers are typically trying to build a consensus. So even though you might have named one person as your agent and maybe let's say you have another child who you don't want making the decision, unless you have specifically excluded them, and there is a way to legally exclude them, but unless you have specifically excluded them, the doctor or the hospital is probably going to invite them to the table, so to speak, for that conversation. That doesn't mean he's going to let them make that decision, but your doctor is usually looking to build a consensus and to use your documents as a means of doing that. Your healthcare agent, though, is the one who has decision-making authority and legally can overrule other people. And so that's what you're accomplishing with that.
Great. We have one more question. When it is determined by an attending physician that a person can no longer make their own decisions, does a form or other means need to be recorded?
No. that was my best effort to be short and brief as a lawyer. So the answer is no.
All right, let's go ahead and move on.
So I think my colleague Jonathan Williams is going to take over for a bit. So Jonathan, take it off.
All right, thanks, Mark. Yep, nice to be with you guys today. Thanks for joining us. And I'm going to talk a little bit about the other legal documents that we use for healthcare planning. The first one is the living will. The living will is the document where a principal gets to make a declaration about their wishes regarding life support or life prolonging measures. So you get a chance in a living will to say, these are the circumstances where I really don't want to be kept alive artificially on life support. And one question that often comes up is, well, what is life support? Can you give me a list of treatments that count as life support and treatments that don't? And the answer is no, because life support is really defined by the purpose for which that treatment is being used. So when we're thinking about life support and whether a particular treatment decision is governed under a living will, we're really thinking about, is it being used for the purpose of helping you getting better, for curative or therapeutic value? If so, it is not life support. It's medical treatment aimed at getting you better. But if a particular treatment is being used only to artificially postpone the moment of death, not because we expect you to get better, but just to keep your body alive for a certain period of time, that's when we're talking about life support. And the same kind of treatment can fall in either categories depending on how it's used. For example, if I have some sort of stomach problem and I need to have surgery, well, there's a decent chance they might put me on a feeding tube for a period of time while my surgical wounds heal. And that's not life support. That's just helping me get better. On the other hand, if I've been in a car accident and I'm in a permanent state of unconsciousness, my doctors have determined that I'm not going to wake up. Well, any feeding tube that I am on is not to help me get better, but just to prolong the moment of my death. And so that would be considered life support. And so that's what we're talking about when we're talking about the living will. We're talking about when would you want to decline those treatments that are really only there to artificially postpone the moment of death. So in North Carolina, under the statutory living will, you have 3 opportunities to decline life support treatment. You can decline life support treatment if you are essentially on your deathbed, if you have a terminal condition that's going to result in your death within a short period of time, typically meaning minutes, maybe hours, some sort of illness or injury that's causing your death. That's one scenario. Number 2 would be if you've lost consciousness and that is permanent. Your doctors have determined to a high degree of certainty that you will not regain your consciousness. And then the third is analogous to that, except instead of losing consciousness, we're talking about losing your cognitive function. So if you have a traumatic brain injury or some advanced end-stage dementia illness that essentially robs you of your ability to think and be aware of the world around you, then you can decline life support under a living will in that situation as well. But I do want to make clear that when you make a living will, you're not declining all care. You're not declining other kinds of treatment. You are only declining the life support treatment. So you're certainly not, if you're in the stomach cancer issue I talked about a minute ago, and you need a feeding tube for that purpose, well, you're not declining that care if you do a living will. You're only declining the life support treatment, and you're also not declining palliative care or pain management or other types of treatment that is designed to keep you comfortable. In fact, the North Carolina statutory form and most of the living wills I've seen in North Carolina say explicitly that I do want to receive the kind of treatment that's going to keep me comfortable and clean and free of pain, even if that hastens the moment of death. And so you're not declining that type of care when you do a living will. One other choice that you make when you do a living will is whether you're making that document to be a true directive or if you're merely making it a statement of your wishes. You can elect whether you want your living will to say that your doctors may withhold life support, meaning they have your permission, but they don't necessarily have to do what you wish. Or if you want to say that they shall or they must withhold life support, in which case you're giving them a directive that they need to follow. You're not giving them options. So you get to choose that when you do the document, which formulation of the words you would like to use. Now, one big question is, well, what about the role of the healthcare agent? If I've done a healthcare power of attorney and I have a healthcare agent serving for me, what's their role in end-of-life decision-making? Well, just like before, you get to decide. The living will invites you in North Carolina to make a decision about whether the final word on life support should come from your living will document or whether the final decision should come from your healthcare agent. You can, if you want to, give your healthcare agent the power to override your living will, so that if you do have a living will in place, but your healthcare agent steps in and says, no, I want to keep life support for whatever reason, you can allow your healthcare agent to have that power if you want them to have it. On the other hand, sometimes you don't. We have plenty of clients in our practice who say, you know, I really don't want my healthcare agent to be in that position, either because I think it's going to be a burden to them, or because I think that that they might do something that I don't want. You can say that they don't have the power to override the document, but you could give them that power if you want them to have that flexibility. And so if they do have the ability to override the living will, you might ask yourself, well, what's the point of doing a living will if my healthcare agent's just going to make the decision in the end? Well, it still serves as a very useful guidepost or roadmap to your healthcare agent, because if you take the time to do a living will, you've said what your wishes are, and then your healthcare agent can use that as a guide for their own decision making when they're in a position to do that for you. On the other hand, if your agent is prohibited from overriding the living will, then their role as healthcare agent really is just to make sure you get what you want and to advocate to your doctors that your living will declaration will be carried out to the extent they can. And of course, you don't have to do a living will. Plenty of people don't do one, and that just means you've not taken advantage of your opportunity to make this declaration. But it doesn't mean that nobody will be able to make end-of-life decisions for you. It just means that will fall to your healthcare agent, assuming you've done a healthcare power of attorney. And if you haven't, well, then Mark will come back in a minute and talk about what happens if you don't have a healthcare power of attorney in place. Let me move on to the other document, which is the HIPAA authorization. Many of you are familiar with the HIPAA privacy rule, which basically means that your doctors or any other medical provider or other covered entity under HIPAA is prohibited from sharing confidential protected health information without your permission. So if your family or friends call up your doctors and want to know how you're doing or what kind of treatment you're getting, ordinarily your doctors are going to have to say, no, that's protected health information. I'm not going to share that with you. If you have certain people in your life that you want to be able to get that information from your doctors, then you would need to do a HIPAA authorization and name them. So you can identify the people that you trust, who you want to be able to talk to your doctors, get medical records, get medical information from your healthcare providers. It's a pretty simple document, but mostly just a list of names, and you can name one person. You could name, a couple hundred people if you wanted to. You can waive your HIPAA privacy rights as to whomever you choose. But we do, in most cases, advise that if people have a healthcare power of attorney, ordinarily it's a good idea to name your healthcare agent on your HIPAA authorization. Any successor agents should also typically be put on the HIPAA authorization. Also, if you have a financial power of attorney or a living trust, then it's usually also a good idea to put those names on there as well. Basically, the guiding principle for most people is that you want your support team to have access to the information that they need to provide their support, to do their jobs well. And so anyone you have put in a a position of authority to help manage things for you, and it should typically be named on the HIPAA so that they can have access to the info they need. But there may be other people in your life. Maybe you have a neighbor, and you and your neighbor check in on each other, and you want your neighbor to be able to get information if needed. You can put them on the HIPAA as well. It doesn't give anybody decision-making authority or power to do anything other than get information. And so, like I said before, you can put as many folks on here as you want. All right, so I'm going to hand it back to Mark, who's going to talk a little bit more, and I'll be back one more time at the end. Back to you, Mark.
Thanks, Jonathan. Just to add to what Jonathan was just saying about the HIPAA and thinking of it not just as something you just kind of routinely do. I think particularly for those of you who might find yourselves in the position of being an important supporter or caregiver for someone who's not, in the same community with you. Maybe you're an out-of-state family member or something like that. The more people who are functioning as your eyes and ears, the better. And so if the person you're caring for, your principal, has friends or people they know from their church or other people who are going to be seeing them on a regular basis, and maybe they're in an assisted living facility or in a nursing home, making sure that those people have the ability to talk to the people who work at the facility can be a real advantage, because that's just one more person who can report back to you and give you input for the decisions that you might make. And again, as Jonathan said, they're not making decisions, but they are able to talk to the people who are caring. So what happens if you haven't done any planning? What happens if you don't have a healthcare power of attorney, or you don't have a living will? Well, so who makes the decisions in that case? Well, first, there's a statutory scheme that lays this out. So really, when you are doing this kind of planning, not only are you being specific, which is very helpful, not only are you providing some substance to what the person is supposed to do, but you're also opting out of this statutory scheme that's probably not what most people would want. The first one is your court-appointed guardian. If you have a guardian, that person is going to be your decision maker. Next, if there's no guardian, it's going to be the healthcare agent, the person in the document, okay? What if you have no healthcare power of attorney? Well, then if you have a spouse, it's going to be your spouse. If you don't have a spouse, the majority of the reasonable available parents and children over age 18 of the principal, okay? That's starting to get a little complicated. Next would be the majority of the reasonable available siblings. So if there are no living parents and there were no children, well, we go to siblings. And then lastly, we go to an individual who has established a relationship with the patient. What? Who is that? Well, I have no idea who that is. That's an individual who has established a relationship with the patient. So that's pretty wide open. And so you can see why you probably want to guide folks as to who would be making these choices for you by making sure that you have that healthcare power of attorney in place. The guardian who takes precedence over the healthcare power of attorney, for most people, doesn't exist. And of course, part of the goal in having a healthcare power of attorney, as well as other basic estate planning documents like a financial or legal power of attorney, is to avoid having a guardianship. What does a guardianship look like? Well, and why would you need one if you had a healthcare power of attorney? So first of all, the circumstance in which you might need a guardianship, even though you had a healthcare power of attorney, would be either where there's a family dispute over the healthcare power of attorney in one way or another, whether or not perhaps the person wasn't competent when they put it together, or whether or not they were improperly influenced in putting it together, might lead to that. More likely, what might lead to that is the person the principal is just not compliant. We've gotten to that point where that person has to, in the judgment of the family or in the judgment of the healthcare power of attorney, be living in a skilled nursing facility, but the person doesn't want to live in a skilled nursing facility. Well, this might trigger a situation where the healthcare power of attorney has no power. I mean, the healthcare power of attorney has the authority to decide that is where you ought to live. They have the authority to take steps to make it happen, but they don't have the authority to take steps to put the principal in the back of the squad car and take them over to the nursing home against their will. That's beyond their authority. So when we get in that situation where we have a non-compliant principal, now we're in a guardianship proceeding. So this is a court-supervised provision in which the clerk of court is really going to function as a judge or a decider, and they are going to determine whether or not the person is incompetent. Now, they're not going to do that until we've gone through a fairly lengthy proceeding to determine whether or not they're incompetent and who ought to be guardian. The clerk can appoint anyone they choose to serve as guardian. They're not required to select family members, and they're not required to really do anything other than follow a few statutory requirements. Typically, you're going to consult an attorney if you're going to need to go through a guardianship proceeding, because really there are some tricky steps to this. First, the idea is that part of estate planning is planning for incapacity. And so if we have planned for incapacity effectively and we don't have that non-compliant party I was talking about, we're always going to be able to avoid the guardianship proceeding. But if someone becomes incapacitated and we haven't done any planning, or we haven't done the right planning, we'll be involved in this public court proceeding in order to determine whether or not the principal is incompetent and whether or not who ought to serve as their guardian. So it's expensive, it's time consuming, but I think the biggest thing is the court is in control. So this is something that you could control, you in consultation with your family could control. But if you haven't done that, you're in a situation where the court, who doesn't really know you, is picking someone to handle your finances, handle your business, but also handle questions like where you live, what kind of health care you have, what medical decisions are made. So again, as I've said, powers of attorney are intended to avoid the guardianship, and we want to make sure that you pick not only a primary, but some successors to make sure that we don't end up running out of named fiduciaries and end up with a guardianship proceeding.
Thank you, Mark and Jonathan. If we could take a quick break, we have quite a few questions coming in. Darcy, would you like to go through some of the questions?
Certainly, we've got some great questions. One is specific to out of state. What if the person who has a North Carolina power of attorney has failing health in another state? Is that power of attorney still valid?
I will field that one. If you're on vacation in another state and you have a health crisis, any legal documents that you've done in North Carolina are going to be valid and honored in that other state. So that's generally not a problem. If, on the other hand, you move to a different state or spend a long period of each year in another state, it may be advisable to get documents that are consistent with the laws in that particular state. Not because the North Carolina documents aren't valid. Like I said, that they will be valid in all 50 states, but just from that practical perspective, like Mark mentioned about the healthcare power of attorney, it's helpful to have documents that the doctors and the hospitals are used to seeing and that use the terminology that they're used to hearing. And so if the North Carolina statutory framework is radically different than, California or New York State or Florida or something like that, and you spend a good chunk of time each year in these other places, well, it's probably going to be helpful to have a set of documents that are going to work there and are going to comport with the way those laws are structured in that state. Mark, do you have other things to add on that?
Well, yeah, just to repeat what you said, Jonathan, I think with any legal document, and certainly with these, there are two questions: will it work? And the second is, will it work well? And it's always going to work a little smoother if you're working with the document from that state. And unfortunately, all of the healthcare documents are state specific. I honestly think sometime in the next 20 or 25 years, we'll get a national set of healthcare documents, and these will be uniform across states. But as we are now, every state is different, and so it helps to have that state's documents.
Thank you. Thank you both. Two quick questions that may just have a yes or no answer. The first is a declaration of a desire for a natural death the same as a living will?
Yes.
Okay, thank you. And does the North Carolina MOST form, the medical orders for scope of treatment form, does that trump a living will?
More or less, yes.
Okay, thank you. Here's a question. Can you, if you want or need to discontinue life support for your loved one, do you need to wait for all family to be present?
If you are the designated healthcare agent and the person does or doesn't have a living will, you will have authority to act in this area. And so the question is, well, do I need to wait for everyone else? From a legal standpoint, you don't. I think most medical facilities will want you to, because most medical facilities are looking for really a consensus from all the family members on things like that. But literally and technically under the law, you don't have to wait if you've been empowered to act.
Thank you. Here's a question. What does the term durable mean when dealing with powers of attorney?
So this is my favorite question. So I'm going to take this, Jonathan. So that's something that usually refers to the financial power of attorney, and not to the healthcare power of attorney. But really, and in that context, what it means is that it survives your incapacity. So it's not something that's to be used just while you're competent. After your incapacity, it still continues to function. And of course, you might think, well, gee, that's when I really need it. So I would absolutely want my power of attorney to be durable. And yeah, I think that's right. And that's why in 2018, we passed a new law in North Carolina that made the default that your power of attorney is durable. Now, that doesn't apply to old powers of attorney that were executed before that law, I believe, Jonathan. But going forward, whether you say it's durable or not, it is durable. Jonathan, can you check me on whether it applies to the old documents?
I believe you're correct, Mark, but I have not looked that up recently. So
right, but durable is good.
Great. Thank you both for answering these questions midpoint. So we will continue with our third section.
All right, and that is back to me. So our final little segment here will be about the role of the healthcare agent. And I know a big part of our audience today are caregivers. And so I'm sure that many of you out there may serve as healthcare agent for your loved one for whom you're providing care. And so we want to think a little bit more carefully about what it means to be a healthcare agent and what's a good way to think about exercising your powers as a healthcare agent. So let's start by asking what the law says about being a healthcare agent. The healthcare agent has the power under the law to make healthcare decisions to the same extent that the principal could make those decisions for himself or herself. So what does that mean? If you're the healthcare agent, how should you think about going about exercising these powers that you've been given? You've been given these huge powers as healthcare agent to make medical decisions, potentially even including decisions about end-of-life care, but just about any kind of major decision is literally a life or death decision. So how do you think about exercising the power that you've been given to make these kinds of decisions? Well, the law doesn't have a lot of guidance on that. The one place it does, when it talks about a healthcare agent making decisions on mental health, the law says that the healthcare agent should be making decisions that are consistent with what the healthcare agent believes are the principal's wishes or what the principal would want to do themselves. So that when you're the healthcare agent, you're not necessarily doing what you think is right or what you think is best, but what you believe your principal would want or what your principal would think is right or best. And that is what the law says as to mental health decision-making. It doesn't say that specifically about healthcare decision-making more generally, but I can tell you, having worked with hundreds of clients, that if I were to poll them and say, okay, if your healthcare agent is making decisions for you, do you want them to use their values and their priorities and their judgment, or do you want them to think about your values and your priorities and your judgment? I think almost all of our clients would say, well, I really would want my healthcare agent to make the decision that I would make based on my values. And so I think if you're the healthcare agent, the first principle would be that I'm not necessarily doing what I think is best, but what I believe my principal would think is best, and what I think my principal would do if they were healthy enough to make these decisions for themselves. And so we've got a particular framework that we use to kind of make those decisions, and it's called supported decision making. This is a legal framework that is not the law in North Carolina, but may be coming. It's a legal framework that has been adopted in a handful of states, mostly in the guardianship realm. that guardians in some states are mandated to use the supported decision-making model of exercising their powers. But even though it's not the law, in North Carolina, we still think it's a really helpful way to think about serving as healthcare agents, making decisions for your
Okay.
And so let's talk about what that means. A supported decision-making model is really something that we do every day. What supported decision-making is just seeking help from trusted advisors. And everybody does that all the time, every day. You know, anytime something breaks on your car and you need to get it fixed, anytime you need legal work done, and of course, anytime you see the doctor because you have health issues, you know, you are seeking help from a trusted advisor. You're looking for someone to explain what's going on, give you some guidance about what should be done, tell you what your options are, give you some recommendations for how you should proceed, help you weigh these pros and cons and make choices, and then help you carry out those choices. And so that's what supported decision making is. And like I said, it's something that all of us do all the time. And when we apply that analysis to the healthcare agent role, well, in that case, the healthcare agent becomes the trusted advisor for the principal. And so even though the principal is not able to understand fully what's going on with their health and what their options are, they've got a healthcare agent who can be a trusted advisor for them, who can explain things for them, give them some guidance, give them some information about pros and cons, come to a decision with them, and then help carry out that decision. This model can be used not only after your principal has become incapacitated and your powers have been triggered, but you can actually use this model even before your powers have been triggered. If you've been named healthcare agent and your principal is beginning to need support, but they haven't yet passed the threshold of not being able to make their own decisions, you can still serve in this role as sort of trusted advisor to help them understand the decisions that they're making and help them make good decisions that are good for them and consistent with their values and their priorities. So the fundamentals for supported decision making are that everybody has a right to make choices about their life, even if they're impaired, even if they're not able to fully make decisions for themselves. They still can make some choices, and with the proper help, they can make choices that are consistent with their values, consistent with their priorities, and therefore will be good for them. And so those are the fundamentals when we talk about supported decision making, is acknowledging people's right to make a decision and helping them make those decisions so that they'll be consistent with that person's wishes and priorities. So if you're the healthcare agent and you're engaging in this kind of support, then the fundamental skill or fundamental practice that comes into play is communication. And communication with someone who has a cognitive impairment or a memory impairment can be difficult. But with practice, you can get better at this, helping your principal understand these healthcare issues and these decisions that have to be made by breaking them down as much as you can to basic parts, providing information for them and asking incremental questions a little bit at a time to test what the person's understanding and what they don't understand, and get to a level where they can understand the issue at a basic enough level that they can give input on a sort of a yes or no basis. Now this can be really difficult. I'm not unfamiliar with the concept of caregiver burnout and the relationship between the principal and the healthcare agent can be difficult in the context of caregiver burnout. And so the earlier you can have these conversations with your principal, generally the better. When we help clients do healthcare planning, we have a resource that we can share with them called 25 questions to talk about with your healthcare agent. And it's just sort of a list of topics that you can have a discussion with, so that your healthcare agent has, again, some sense of what your values are, what your priorities are, and what's important to you, and things that you would or wouldn't want done in certain circumstances. So the earlier you can have those conversations, the better. And so if you're the healthcare agent and we're thinking about it in this way, you should know your principal. As attorneys, we are allowed to serve as healthcare agents for our clients, but it's really rare. We reasonably regularly will serve as trustee for them, or a financial power of attorney, but serving as a healthcare agent for someone is a much more intimate relationship. And ideally, you really want to know your principal really well if you're serving in this role. And anytime you have to make a decision as a healthcare agent, if at all possible, consulting with your principal on the decision to be made, explaining the issue, explaining the options, explaining the risks and benefits, making a clear recommendation, and then seeking the input of your principal. And if you believe that your principal understands things at a basic enough level that they are making an informed choice, we would urge the healthcare agent to help that principal carry out their wishes and do what they want. If you disagree with their choice, by all means, you should be letting them know what your concerns are. And in fact, you may disagree with their decision in such a way that you really believe that they're not understanding it fully. And that can be a fine line to walk as to whether you believe that your healthcare agent is making a decision you disagree with because they don't understand the issues fundamentally, or if it's simply because they're making a choice you don't like. It's sometimes really hard to suss that out. But again, we urge folks to the extent they can, allow their principal to have as much autonomy and as much input as possible. And if there's a clear wish that the principal is expressing, in most cases, we want to help our healthcare agents carry out that wish and not thwart it. And such that you would be overriding your principal's wishes only in the rarest circumstances. So again, this is sort of summary here. A healthcare agent ought to be using the principal's wishes and values as a guide. A healthcare agent can use the supported decision-making model as a way to make sure that their duties are carried out in a way that's consistent with the principal's intent. And that's true even after your authority's been triggered, even after the doctors have determined that your principal is unable to make decisions. This is still useful analysis and can help your principal feel more valued, feel more like a participant in their own life, feel like they have a higher likelihood of getting the outcomes and healthcare that they want. And of course, this won't last forever. In many cases, particularly with a dementia illness, there will come a point where the principal effectively loses the ability to understand in any fundamental way or communicate in any fundamental way. So there is a limit to this, of course. But again, we encourage. We think it leads to better outcomes and better relationships when you're involving the principal as much as you can and helping their wishes get carried out as much as you can. Final thing about managing things as a healthcare, this is a little bit off the topic of supported decision making, but another thing to think about if you're a healthcare agent is your role as sort of a team caregiving kind of coordinator. If you're the healthcare agent, it would be your job, if you're serving, to figure out what your principal needs help with and sort of marshal the assets or marshal the team members that you will need to meet those needs. And so, figuring out if there are services that you can provide your principal, like running errands for them or managing their medications or whatever. But sometimes you need to enlist support. And so there you may enlist other family members to help you with these things. You may hire private services to meet these needs. But another role that you have when you're the healthcare agent is sort of coordinating this team of making sure that the principal that you work with has their needs met if they're unable to meet those needs for themselves. So the big takeaway here is that planning is good, and the earlier you do the planning, the better. As Mark said, if you don't do healthcare planning, there will be a way that decisions can be made for you, whether that's through a guardian or through an indeterminate set of family members or just some unnamed person who has a relationship with you and can show up and make medical decisions for you if nobody else is available. So the earlier you can plan for these things, the better. So we encourage folks not to procrastinate about this. One other piece we did want to mention is that we do have a book that goes through some of these issues as well as a lot of others, and we can answer questions about this book that we have. Mark and I and a couple of other attorneys wrote about coordinating caregiving services in North Carolina. It gives some good information about estate planning and elder law planning and healthcare planning and things like that. But from here, I think we're just going to see what questions we have.
Yes, thank you guys both very much. Darcy, I believe we have a few questions in the Q&A.
We do. We have several that relate to HIPAA, specific to kind of who has the form, who has authorization, who has access to information. And I know that's a big question. And if it's too broad for today, if you could lead people to a resource that might be helpful. We've also had a few more questions about out-of-state specifics with healthcare, power of attorney. So maybe what we are also looking for is some documentation.
Well, so I did see in the Q&A a question from someone about different or competing medical privacy forms. And there are certain government agencies that have their own specific powers of attorney or their own specific HIPAA waivers. And where they do, they require that you use those. And so there are, if there is a specific agency that has a specific form, that applies only in dealing with that agency. And so it doesn't apply for other purposes. So the broader waiver relates to broader healthcare decision making. And then my sort of general comment about out-of-state documents or moving from jurisdiction to jurisdiction is particularly in the healthcare arena, you want to have local documents if you can. I will say that the threshold for competence for someone to sign legal documents may not be what you think it is, which is to say, even someone who is not able to take care of their day-to-day affairs due to disabilities, some of which might be mental, is not necessarily prohibited from signing a new power of attorney. That's a judgment as attorneys we make on a case-by-case basis, basically based upon what the person understands. You can't sign a document where you don't understand what you're doing and what the alternative is, but you might be able to do that even though you have great memory lapses. And typically, the memory lapses won't matter, which is to say, if you know what you're doing at the time you sign it, it may not matter that 30 minutes later you don't remember signing it. So do not assume that someone who would benefit from having their out-of-state documents turned into North Carolina documents can't sign. That's really something you want to look at the earliest possible occasion to see if there might be some possibility that they could create a new document.
So Mark, can you take that one step farther? What about if the individuals are homebound? Are there ways to do documentation today over a website? Can we make it secure and can we make it legal?
No, because these documents have to be notarized, and in North Carolina there is not a permanent arrangement for remote or notarization. We have a temporary remote notarization statute, which I'm not even sure if it still applies. How long does that run, Jonathan?
It's been extended at least through the end of the year, as I recall.
So that is COVID-19 related, and that's premised on the idea that due to COVID, it might not be possible to get into, say, someone in a skilled nursing facility because they wouldn't allow outside visitors. It's not a very user-friendly exception to the rule that the notary has to be present, and where witnesses are required, the witnesses have to be present. So now that we're a little more open in facilities and folks can come into most places, it's just a case that to do this, you're going to want to have your lawyer or law firm be present with a notary, which is what we do for folks.
Thank you. And another question about the forms: how often should they be updated? Is it a particular milestone, or is it based on changes in health, changes in your surroundings, all of the above?
Well, so we encourage our clients, who are folks we work with regularly, to update them regularly, just to put a fresh signature on them, even though they may not be making any changes in their decisions, so that when they do have these documents presented to a doctor or a hospital, they're more recent, and therefore the third party has a little more comfort with them. It's not that a 12-year-old living will isn't legally enforceable. It's just that the hospital might feel more comfortable taking action based upon a 2-year-old living will than a 12-year-old living will. Well, so you have to balance the convenience and cost of doing that. And to be honest with you, there isn't a great deal of cost associated with updating a living will in a situation like that. So we do it. There are occasions where the statutory framework for these documents change. In North Carolina, the living will and healthcare power of attorney haven't changed since 2008. I know there's an ongoing discussion now to make some changes in them. And I think that when those changes occur, it's always the case that your existing document on the old platform is still legally enforceable, but you will want to, in time, switch over to the new one, because you'll want to be on the platform that the healthcare providers are most used to seeing. And over time, like right now, if you have a living will on the old pre-2008 North Carolina scheme, it's legally enforceable. But I would guess most of the people at the hospital haven't seen it for so long that they wouldn't know how to interpret it without getting some input. And plus, it's not very good. I mean, the whole idea behind people changing them is they usually think they're improving them, and usually they are. And so they get a little better. It gives you an opportunity to have a little more control over your decision making. And I think control is something that most people would like to have.
Thank you. We've had a lot of questions about the book. So Mary has kindly re-included that title in the chat. Also, we are going to upload this recording to the caregiverssummit.org website by the end of the day. We've had several requests for the slide deck. Because that's part of the recording, you'll be able to see this content again and listen to it again. So let me look really quickly and see if there's another question. I know we're getting really close to the end of our hour. How about, this is kind of a specific question, is the CMS 10106 form, authorization to disclose personal health information, the same as the HIPAA form to get information from Medicare?
Jonathan wants to take that one.
Yeah, I can't cite chapter and verse on that one. I'm not certain without looking more into it what that form is, other than to reiterate what Mark says, which is that some financial institutions and some government agencies do have their own forms that they prefer that they use, and sometimes they require that you use them. So it is possible that that's a form that has to be used, and that a HIPAA can't substitute for it. But I wouldn't know without looking more at the form in particular. I don't know it by its serial number you gave. I do want to add one other comment though, Darcy, about the book. If folks are interested in getting a copy of that book, we're happy to get it to you. We sell it, but we don't have them on any sort of e-commerce site anywhere. So if you would like to get a copy of the book, you just can contact our firm. You can contact us through the website, or you can just call our office, and we'd be happy to get you a copy of the book.
Wonderful. It looks like we're just about out of time. So we want to thank first our guest today for this excellent review of legal planning for healthcare. As Darcy mentioned, the session was recorded and will be posted on the website later today with resources. And another reminder that our next webinar will be on Thursday, April 15th, next Thursday, also at 2 p.m. And we'll be covering how to pay for long-term care. We really encourage you to join us, and we hope to see you there. Your registration and the Zoom link you received for today's webinar are good for all 4 weeks. So it's just clicking into the same link that you clicked into today to get to next week's webinar as well. If you have any questions, please email us at summit@transitionslifecare.org. Once again, that's summit@transitionslifecare.org. Thank you so much, Jonathan and Mark.